Hello, everyone. Good morning, good afternoon, right? And we are about to start the webinar and we're just gearing up with energy. So, by the way, I'm joining you from Bangalore right now. Mahima and Bhaskar are joining you from our Noida office. So, while we have been working on DPDP Act and while the rules are live, while obviously the draft rules are live, we're still giving comments, still there will be some suggestions, and then the law will get complete. I think while the law came out, one thing that became really, really clear is the rules are addition to the law, right? So the human rights do not change, the principles do not change. What has changed is what has been added is more specifications, right? More pointers, pointed directions toward building your notice, building your consent. How do you report the breach? How much time do you have to respond to a data subject request? So these type of things are coming up more and more. But how do we get to know? I can see a lot of summaries going on in online. People are posting right, left, and center. Let's slow down a bit. You know what I'm saying. Let's gear a bit down and let's just read the law together. Right. By the way, I'm joining you from Bangalore Airport live. My flight just landed a bit late today, so couldn't get my house. So say hi to Bangalore Airport, guys. Looks beautiful, by the way. So I hope you're enjoying wherever you are as well. I have with me Mahima and Bhaskar. Both are part of our privacy SME team. Bhaskar leads our DP as a service as well as leads our privacy practice in our technical implementations. And Mahima being an expert with us. So Mahima and Bhaskar both are here. And folks, Mahima and Bhaskar. Bhaskar, over to you. And then Mahima, let's get going. I think it's 11:06 right now. So I think a lot of people are still joining in. So let's just wait for 2 more minutes. Give your introduction quickly, and then also brief us how the session is gonna go on, Mahima, and then let's get going. Let's kill it. Yeah.
Sure. Thank you, Akash. Thank you, everyone, for joining us. We are going to read these rules to understand how this DPDP, the privacy law in India, will be implemented and what the government is expecting, how the companies have to shape their privacy posture. And that's what we will be doing today. Over to you, Mahima. Thank you.
Thank you, Bhaskar and Akash. So basically, there's a lot of buzz about the rules, and now that the rules have been published by the ministry, the rules were highly anticipated as to the expectation that what would they have in them, how would they address the operational challenges that were there, the implementational challenges, the procedural gaps, and the areas where the act required clarity. So the rules at some place has brought in some clarity where there is still a consideration that needs to be there is a significant roadmap still there that needs to be addressed. So when we'll go through these rules as we do the reading together, we'll address where the law has brought in some clarity and wherein the act still has a long way to go and we need more clarity. That's why there is public consultation, and so that we can send out our comments to the people for addressing this. So wait for one more minute and we can start with the law.
Yeah, let's wait for one quick more minute. And hello, everyone. Where are you joining us from? Where, and why don't you just drop a comment on LinkedIn so we get to know each other a bit more? Also, if you have a question for us, right? We have analyzed the law right, left, and center. We have built our frameworks, upgraded our frameworks. If you have something that you want to know about today, drop that text into the questionnaire and we will make sure that you can get your answer today before the session ends. Yeah. So I've also dropped my comment for all of you that I'm joining from Bangalore. Though the problem is I'm joining you from airport today, not even Bangalore, right? Bangalore and airport are two very different things, guys, right? I don't know how many people have come here. So still a long way to go. I think the flight from Pune was what, 2 hours? I think same from Bangalore airport to my house. So still, the wind goes on, and I think let's not waste any more time, right? And Mahima, why don't you and Bhaskar, take it over and let's get going. Let's hit and teach people what they are here for. And by the end of the session, folks, in another 30, 45 minutes at max, we will also give you the white paper on how you should implement these laws, right? So what we will do is we'll quickly put those links in the group here. So if you stay with us for 30 minutes, 35, 40 minutes, you will get the white paper and you can use Saro's guidance to implement privacy in your organization in the right fashion. Buy what you need, not what you want. Remember that. Mahima and Bhaskar, over to you.
Thank you, Akash. So let's start. So these rule has been published by the central government on 3rd of January, exercising their power under Section 40 of the Act. And for there, they have published around 22 rules and have 7 schedules in it. So basically, what the government has stated as planned for us for now is that from rule number 3 to 5 and 21 and 22 would have a different enforcement range from the other operational provisions of that. So for these rules, we'll have two implementation that unlike other rules that we usually have. So we'll have two dates. The moment the gazette is published, we'll have the board being set up and other operational challenging being uh, sized. Apart from that, then we'll have the main provisions being implemented. So first thing that we'll discuss today is the rule 3 that talks about the notice. So here, as you can read, the rule 3 talks about that you need to provide a notice to the data principal about the purpose for which it is being published. So as you see, the keyword here is the implementation, that the notice has to be independent from any other permission that you're being taking. It has to be in clear, plain, simple language, and it should be understandable by the data principal. Also, it should have now an itemized list of all the personal data that is being collected or processed, along with the detailed description as to the goods and services that are being offered by you for using that process for the purpose for which it was authorized for you to process. Apart from that, they put a duty on the data principal to provide a communication link in the notice itself for them to visit your application or the website. And also now you have to give data principal an option to withdraw their consent or exercise any of their rights that has been given in DPTPA to in the notice itself. So they can exercise their right or know their rights from the notice itself. Moving on to the next provision as we see. So Bhaskar, would you like to take up rule number
Yeah.
4?
So I think in rule number 3 also I would like to add on to it. It talks about a specified purpose because companies while taking personal data, while collecting personal data, list down certain purposes, and now these rules require the organizations to provide specific purposes for which you are collecting personal data or for which you require personal data. So I think this is going to change the game a bit because earlier companies used to club multiple purposes which were incidental or which were not related to each other, primary and secondary purposes in the same notice. Now it has to be a specific purpose for which you are collecting data, and that will relate directly to the consent that you are collecting. If you talk about rule number 4, this is about the registration and obligations of consent managers. So, in the first schedule, Part A deals with the requirements of the conditions of who can be a consent manager, and Part B of the first schedule talks about the registration and the appointment of consent managers. So, these are certain conditions and the powers of the board which can deny or accept the appointment of a certain consent manager. That is what the Rule 4 is all about. Yeah, over to you, Maima.
Yeah, so we have a comment here wherein people are asking whether a consent manager is a mandatory requirement under the rules or along the law, or is it that the organization has it as an optional option. So here, when you read the main act, there wherever the word consent manager has been mentioned, there the word used is may and not shall. So as per the reading, it reflects that the requirement of consent manager is optional and the organization may or may not appoint a data consent manager. It's not a mandatory requirement. If you have a consent management framework that is adequate and fulfilling all the requirements mentioned in the act as well as the rules, so it's not an obligation upon you to have a data consent manager appointed for your organization. So moving on to the next provision, as we talk about Rule 5. So basically, it talks about the processing of provisions or issue of subsidiary benefits, services, certificates, license, or permits by states and instrumentality. So, as we read in the main act in Section 7, where it talks about legitimate users and the exceptions as mentioned in Section 17 of the act, it talks about certain powers that has been given to the state government wherein they can process the personal data of people without having the requirement or obligation to obtain their consent. So it here brings a little more clarity on how the state can process and for what purposes the state can process this personal data. So here they have also mentioned in the schedule how it could be used. So basically here they sums up that any subsidiary benefit or a certificate that has been issued by a state or any of its instrumentality with the funds being given from Consolidated Fund of India or any of the public funds, then in that case, if it's for public beneficial, it's for some beneficial purpose, then the state does not need to have your consent being recorded for processing of your personal data. Apart from that, what it mentions here, it's some reasonable technical and organization measures that even the state has to take. In the schedule, it mentions that you can, even the state for that matter, can do it for only a lawful purpose and have to exercise the purpose limitation principle and cannot use it for any other purpose apart from the subsidiary benefits that they are going to give to the data principle. And also here they talk about though the consent requirement has been obligate, it's not obligatory, but you have to give the data principal a notice that hey, this is for this purpose, I'm utilizing your personal data, and just in
So
notice that.
notice has to be specific to the point, and consent also has to be granular, right? I think the what the clarification of the rules has come through is saying that so sorry, that the specific consent has to be taken. Yeah, am I
Right.
am I correct? And also, folks, just a quick guidance for all of you. If you're watching us on mobile, come to laptop, right? It will be a bit easier for you to read with us together. Also, if you're on laptop, a quick guidance, try to do it full screen, right? So that you can read it well, right? We are just, I don't know if you have the PDF already, but you can just get it from dpdpa.co.in. So if you just go there on the website, you can just download it quickly if you want to do it yourself. Mahima and Bhaskar, back to you.
So this provision that I talked about sums up how the state is going to use your data, personal data. The next it talks about, since we know the security angle is something which is very important when it comes to securing your personal data. So here now the rules have laid down certain bare minimum standard that at least you need to have when you are dealing with personal data. So basically, they talks about methods like encryption, obfuscation, masking, and using virtual tokens, etc., to protect the personal data. Further, they talks about that you need to have access control, you need to have visibility around who is using the data, you need to maintain the backups of the data, and in case there is an unauthorized access to your systems, you need to maintain the log as to what was happening for at least a year. So it's a mandatory requirement. Here, one
Yeah, I
thing
think
that
this
needs
is
to
a add-on. Mahima, if you see now,
right,
this is a add-on. I was talking to Supratim on my podcast at Privacy Cast, and we specified on this that unauthorized access has not been generally seen in other privacy laws, but while it's
right.
covered here under the breach reporting as well. So that's something that people should listen very carefully on. Yeah, back to you, Mahima.
Yeah, I think
Right.
I'll also add one point here. In terms of retention of logs, there's a specific requirement of retaining it at least for a year. So I think that's something which is going to provide additional accountability. Yeah, over to you, Mahima.
Another thing that's interesting to note here is they have specifically mentioned that in case you are getting into a contract and you are appointing some data processor for processing your data on your behalf, you need to have in contracts these details that they are also following these reasonable security safeguards in order to maintain the hygiene, privacy hygiene within the organization and protecting the data. So this is an additional requirement that now even in the contracts, it's mandatory to have these clauses. Now, moving on to the next thing that has been mentioned here. So earlier, we just had in the Act, there was no clarity how as to how the breach protocols are going to function. Here we have a clear timeline now in the rules that how this breach notification has to be there, what all elements has to be there that needs to be reported in case there is a personal data breach. So as we read on to rule number as we read into rule number 7, it talks about intimation of the personal data
So
privacy.
now we are on 7, right? Bhaskar, would you like to summarize quickly for our listeners about 1 to 6? Like, what are these top things that they should keep in mind while we move to 7?
Sure. So in the starting, there's a notice requirement which requires the companies and the organizations who are collecting personal data to provide a clear notice in an understandable language, plain and simple language, which tells the individuals about what data is being collected, why it is being collected, what is the purpose of processing. So there has to be specific purpose for which organizations can collect personal data, and for which the consent will be provided, and the consent should be informed consent. The people should be informed about the data processing activities which are going to be undertaken by the organization. Then you have the security safeguards under rule 6, I guess, yeah, which provides like sufficient security safeguards should be there, including access management data, and the security techniques like encryption, masking, or whatever the organization chooses to do. But at the end of the day, the organization is required to maintain the security logs for at least 1 year, so that there can be accountability of detecting what has happened with certain data records. And then there are rule 7 talks about the notification requirements in any of the data breaches, where the organizations are required to notify the individuals about the data breaches, and organizations are required to notify the board, the data protection board, about any of the data breaches. Yeah, Mahima, over to you.
Right, as Bhaskar mentioned, that you have to notify both the data principal, the individual whose data has been breached, along with the data protection board about this breach that has happened in your organization. What is interesting to note here is that unlike GDPR, the data breach here has not been differentiated based on the risk that it is creating. Even if it's a minor breach, you have to report it to the data principal as well as to the board, irrespective of the parameter or the effect that that breach is gonna have on the data principle or on the general privacy hygiene of the organization. You have to report it and give it information to the board as well as to the data principal that hey, look, this breach has happened, and they specifically meant listed out the things that needs to be there when you are sending this notification of data breach to the data principal as well as to the board. So for data principal, you need to tell about all the description as to the breach, including the nature and the extent of the breach that has happened. What is interesting to note here is they have also mentioned that you need to even in fact inform the data principal what was the timing and the location of this occurrence. Apart from that, you have to tell them about the consequences that are likely to arise from this. What are the risk mitigation factors that you have undertaken in case of this breach? And apart from that, you need to tell them what safety measures they can take in order to protect their data, and also mention the business contact information of the DPO or any other person that you have, so that they can contact you in case they want to contact. And apart from that, to the data principal board, you need to intimate without delay. So they have a timeline here. Now we have a fixed timeline of 72 hours. So we need to inform the data principal, the data control board about this breach within 72 hours. So here also there's description that needs to be given. So they talk about that you need to send out an updated and detailed information of the description, the broad facts of the event that happened. So you need to give a summary of all the things. What was the circumstances due to which this happened? What was the reason behind it? The measures that you took to implement and propose to control this risk, what are your mitigation factors, and also any finding regarding the person who caused the breach. So here they have put accountability, they have asked for the name of the person or the problem through which there is this breach happened. So you need to make somebody accountable and report it to the board that hey, because of this person or because of this thing, this breach happened, so that future action could be taken. Also, you need to specify the remedial measures you are taking now to control the damage that has been happening because of this breach. So this is something now they want a detailed report as to even a minor breach, so that they can protect the future generation about any of the breaches and safeguard them. So let's take up some questions now. Bhaskar, would you like to answer some of the questions that we have in the chat?
Yes, sure. So I think I saw one of the questions where it talks about whether the DPO can be consent manager or something like that. No, DPO cannot be consent manager because consent manager is accountable for managing consents, and DPO is someone who's like on the accountability part of it, like maintaining data privacy posture of the companies. And we talk about 2 years in banking and fintech, okay, retention for 2 years. Yes, the minimum retention period that is prescribed here of 1 year in terms of security safeguards, in terms of access logs, that is the minimum prescribed time period. If you have a business case and valid justification, depending on the industry sector you are operating in, you can have a higher period for retention of those logs and records. Notification requirements, yes, 72 hours in terms of breaches. And I think, Mahima, also when you talk about the breach notifications, I think this additional responsibility of identifying the person who is responsible for the breach, I think that is something new, which is a deviation from the global privacy laws, major privacy laws that we have seen so far. Yeah, over to you. I think we can continue with our
Right.
reading.
So let's move on to the next provisions, the rules that stated. So rule number 9 talks about time periods. So now we have fixed retention timelines for certain classes of data fiduciary who need to adhere to a certain timeline. Apart beyond that, they cannot keep the personal data of any individual. So the schedule basically talks about the time retention schedule. So they have made organizations have to adhere to that, and they have to delete the data as soon as the time period expires. So basically, they talk about three classes of data fiduciary. One is about the e-commerce, another one are the gaming platforms, and third is the social media intermediaries. For all of them, from 3 years, 3 year data retention period guide schedule
For
has been.
Facebook, so for Facebook, somehow all the governments, right? Even if I look at EU DSA, right, Digital Services Act, EU DSA specification on this question, to WhatsApp, Metas of the world, Googles of the world. I think it's beautiful to see how regulations are so focused on certain companies, right? Because once you can influence, let's say, overall data sets of a country, right? I think this is the right approach also to go forward, right? Learning also from Europe in terms of policy. I think putting this clause, I'm really appreciate. Though in verifiable consent, I have questions, right? I have a lot of questions around verifiable consent, how it will be possible. But here, I think looking forward to a great law, a great rule coming in. Yeah, back to you, Mahima and Bhaskar.
Yes, so for time period here, one more provision that needs to be here is we have another timeline with respect to informing. So we have a 48 hours timeline that before completion of the desired period for which you can retain the data, you have to again send out a notice to the data principal informing that hey, we are going to delete your data. If you log in to the device again, we will not delete your data. Or if they raise any of their requests regarding or exercise any of their rights, then their data can be preserved. Apart from that, you will have to delete the data within the expiry of this 48-hour periods once the timeline has been completed. So here again, you are informing. So as a crux, what one can see is with every step, we are informing the data principal as to how and where we are utilizing his data, what is happening to his data. So there is continuous check that is happening with respect to the usage of data. This is what I could understand by reading the act as well as the law. So the intention here is clear that there needs to be transparency maintained throughout when we are using personal data. Then, talking about rule number 9, it says that you have the data fiduciary, it's obligatory on them to publish on their website as well as on application the medium through which the data principal can exercise his rights and the business contact information of DPO in case of significant data fiduciaries so that the data principal can get answers for their questions. And then, as Akash mentioned about verifiable consent, we move on to the provisions of verifiable consent. Though we have obtained a little clarity as to how this is going to function as compared to what we knew in the Act, but still there is a significant amount of clarification that is required as we read onto it. So there are a lot of problems that still needs to be addressed as we see the provision. So basically, it says that you need to have verifiable consent for processing of personal data for two vulnerable classes that they have clarified. So one is for child. Child in India is generally an individual who is below 18, and then for persons with disabilities. So there you need to have a verifiable consent from either the parent or the lawful guardian. So basically, here they say is that as soon as you declare yourself to be a child or person with disability, the data fiduciary should observe due diligence and for checking. Then they have to obtain a verifiable consent of the parent or the lawful guardian, as the case may be, and then verify the individual's identity, that and establish, also not just verify, also establish their identity, that yes, this individual is a parent and is an adult and giving out a consent on behalf of the child or a person with disability. So here they have talked about two methods through which it can be done. One is either the data fiduciary takes on the responsibility of establishing the identity by taking on to the documents on his platform and then verifying it and establishing the identity, age proofs, etc. And the another word is where the data principal, for that matter, the parent or the legal guardian himself voluntarily provides the details as to the identity and age via a virtual token method or by using some government entrusted platforms. Like, for example, they have used the mention of term like DigiLocker and digital lockers, etc.
Yeah,
Where
and I just want to add on to exceptions, right? To exception to this is schools, childcare, right? As well as I think a few more, right? Two, three more pointers to that. So there's an exception as well. But if you specifically again look at social media, you look at gaming, right? I think if you look at the law, it's kind of directing us towards there, right? The challenge that me and Nikhil, I was just recording this in Privacy Cast again with Nikhil Narendran, right? What we were discussing is that, hey, how do we actually get this to people? Because now the question of verifiable consent will not just be about taking a consent, it will become a question of digital literacy of the country. So when we are 1.4 billion people in India, I think any privacy law across the world, whatever they are, the mother of privacy laws, father of privacy laws, I think the DPDPA will actually be the biggest law of the world. We will be the father of the world in privacy, because here the technology has to adapt and change it super fast to be able to adopt this. So I think exciting times ahead, but I think all the questions about being behind in privacy, I think we are going to get really really fast, really really ahead very very soon across the globe. So looking forward to that. And Mahima and Bhaskar, back to you.
Right. One more thing that I would like to add on what Akash said. So, as you read, as you can see the screen, and if you read the illustration, so even if you read case number one, first thing that you'll see is C informs TF. Case number two, again, it says C informs TF. Case number three, P identifies himself. So, one thing here you'll note is the problem is that it is the child or the person with disability
I
who
just
has
want
to.
to I just want to add on to this amazing chat that is going on between Shweta and Chinky, right? Chinky and Lavanya, Miss Lavanya. So, so how it's happening is she actually had a problem. Said, hey, my questions are not being answered right now. But Shweta Garg actually responded. Thank you, Shweta, for responding. And folks, all the senior people, amazing DPOs, CISOs are here on the call right now, general counsels. Thank you for being here. Also in the chat box, please drop in your comment, drop in your suggestion, and drop in an advice. And I know most of you here have my number, right? And we keep talking. Drop me a text if you want to do something or learn something, or if you want a white paper, just let us know. By the end of the session, by the way, we're going to release the white paper, how you're going to implement DPDPA. Just wait for it. It will be on the chat for you. And I hope we have not missed a lot of questions. I think there's another question of what is significant data fiduciary. Just wait for it till the end. I think it will get answered, right? And if you're not able to cover everything today, we're just gonna schedule another session for reading, right? Maybe we are doing it today, maybe we're not able to complete. Then we can do it on Sunday, maybe, right? We'll have more time. So we can continue this session there. Back to you, Mahima and Bhaskar. And joining
Right.
you
So
from Bangalore airport, guys. Right, joining you. You wanna see how it looks? Yeah. Just having fun with all of you. Bhaskar and Mahima, back to you.
So continuing to what I was saying, see, the primary obligation here when you read the law is upon the individual itself to declare. So the question and the contention that needs to be addressed is what happens in case the person does not voluntarily give out this information that he's a person with with disability or the child. Does the organization still has the responsibility of maintaining these additional compliances or verifying, where does the due diligence part end? What exactly is due diligence? How, till what stage do you think the organization would be held liable, and from where they can said to have adopted all the reasonable parameters? Another issue that has been highlighted here is we are taking additional information, so we are collecting more data, so we need to have more compliances around it. So this is something, with every step we are taking additional personal data which needs to be protected again. So these are some of the contentions around this, and we need more clarity on these provisions. Bhaskar, would you like to add something?
No, I think you've covered this one. Yeah.
Yeah.
Just move forward.
So then moving on to the exemption, as rule number 11 talks about the exemptions, as Akash was mentioning. So basically, the rule talks about section 9, that it says, so section 9 of the main act talks about that you can't use child data without obtaining the verifiable consent, and the section 3 talks about that you can't do behavioral analysis and targeted advertisement of the child's. But they have specified certain parts. For example, as Akush mentioned, if you are giving out healthcare services, you are into healthcare services or offering childcare, or you are involved in transportation of a child to childcare or schools, etc., therein you are exempted from obtaining this verifiable consent, and you can process the children data without having the consent from the parent. So there a little bit of relief have been given to the organizations which do require it in order for the beneficial of the child or the person with disability. Moving on to the next pointer, the rule number 12, which talk about additional obligation of significant data fiduciary. As we had a question also around it, that who is significant data fiduciary? As we read on to the law, this is another problem that is there with these rules. They have not specified as to who would be classified as significant data fiduciary. They have just made it more explanatory as to how the obligations of the significant data fiduciary are going to take place and what all are his additional obligations. They have not specified who would fall onto the category of additional significant data fiduciaries. So
So, guys,
basically,
yeah, sorry, ma'am, just adding on here, the question about significant data fiduciaries. So, under the DPDP Act, it has been said, it has been written that government will notify certain data fiduciaries, that certain organizations who will be notified as significant data fiduciaries based on certain number of factors, like the volume of personal data they are processing, the risk that is there involved in that processing, any national security issues, any of the I think personal or public interest, yeah, national security, public interest issues. So based on certain factors, government is going to notify certain data fiduciaries as significant, but that has not been done yet. Under this rule, the obligations have been clarified in terms of annual data protection impact assessment, annual data protection audit, and the reports of these audits and data protection or impact assessments to be prepared and submitted to the board for review. So that is what has been clarified in the rules now. Yes, Maima, over to you.
so as the addressing the comments that we have, yes, we are not clear as to who would be a significant data fiduciary, and we just have the requirements that they need to have an appointed DPO for themselves, they need to conduct DPIs, they need to have an independent audit. These only we have, as has been specified in section 10. We don't, of the main act, we don't have any clarification as such as to who's going to be a significant data fiduciary. It's upon the central government, as Bhaskar mentioned, to decide as to who would fall under the category of significant data fiduciary. So here, as Bhaskar mentioned, we need to conduct DPIAs. We need to we send an audit report to the board itself. So anything, any observation that you have based on the DPIA that you've conducted and the audit, we need to furnish these reports to the board itself. And here also, like GDPR mentions the concept of automated decision making, here also they mentioned that a significant data fiduciaries shall observe due diligence to verify the algorithmic software deployed by it for hosting, display, uploading, modification, etc. of the personal data. So the risk that they possess in case of automated means that are utilized by them for processing the personal data, there also they have this now extra responsibility of observing due diligence, which has been specifically mentioned in the pointers 3. Apart from that, they're based on the recommendation of the country. Here also they need, based on the amount of data they are processing, they cannot transfer it cross border. So here also there is restriction on cross border. Again, the provision which was of contention in the bill of the act, which was not passed by the parliament and was later removed, has been brought in again here in the rules, wherein it gives the power to the central government that they will decide whether the data could be shared outside India or not. So still the primary, we can say, decision maker as to which data can be shared cross border would be again the central government deciding on various parameters, which has not been cleared as of yet. So the central government is going to notify a list as to the countries or the places wherein this data can be transferred. Then moving on to the rule number 13, it talks about rights of the data principal. Here we have just the clarifications as to the rights given in that. So here also they talk about that you need to mention out the medium as to how they can exercise their right both on your application as well as app. Consent manager also has to publish this on its website or the application. They have to talk about the details of the means they can use, any particular IDs. For example, in fintechs, they have customer IDs, which is unique to that particular data principal. So they can mention, they have to inform the data principals that, hey, this is your specific ID, you can use this and send out any of the data principal right request that you want to exercise. Then they talk about grievance redressal mechanism, that you need to specify the grievance redressal mechanism with regards to the right of nomination. They've specified that the data principal can nominate one or more individual for as his nominated individual for exercising the right to nominate. Then talking about processing of personal data outside India, as I mentioned, that even though you are here, if you see these rules bring into the extraterritorial effect to the law and says that transfer to any country or territories outside India of personal data processed by data fiduciary. The B clause talks about outside the territory of India in connection with any activity related to offering of goods or services to data principal within the territory of India. So even if you are operating from outside, though the data that or the goods or services, if you are offering it to data principals who are Indians to India, then in that case, even if you want to transfer that data outside India, it would be considered a cross-border data transfer and you need to follow the rules made by the government. Now let me
Yeah.
just look
Let me
at the
let me take some questions.
right.
I think DPO and consent manager. This question is popping up. No, DPO cannot be consent manager. Consent management of consent is the job of fiduciary. That is the company organization which is collecting consents and processing personal data. And job of DPO is to check whether the company is adhering with these requirements or not. So it will be a conflict if the DPO becomes a consent manager as well. Then about mandatory requirements of appointment of DPO. No, it's not mandatory to have a DPO. It's there for significant data fiduciaries, but not mandatory for every organization. But what is mandatory is to have a point of contact who can handle who can handle any request or related to personal data processing. So it needs to be a person like a privacy officer or someone. But yeah, the mandatory DPO requirement is not there for all the organizations. It's just having a point of contact for resolving those issues.
Also, looking at the comments, I've seen a lot of comments talking about who could be a consent manager and can OEMs or CPMs, etc., like OneTrust offering their services for managing the consent be consent managers. So, anyone who fulfill the requirements of Part 1 of the schedule can be a consent manager. First, they need to register themselves with the board. They need to be a company incorporated in India. First of the requirement is that. Apart from that, they need to have a 2CR annual return. Apart from that, they need to establish that there is no conflict of interest arising in with the interest with any of the data fiduciaries. So there they can't have any of the key managerial persons or the directors or any financial or pecuniary relationship with the data fiduciary. In that case, if there is any conflict of interest, then in that case they cannot be consent managers. And if they fulfill other requirements, they can be. So the first thing, the major conflicting part could be the conflict of interest. If there is established conflict of interest, then in that case you can't be a consent manager. So moving on to the next part, as we talk about Rule 15, it talks about exemptions. So here also they have talked about exemptions. So in this case, they talk about for research, archiving, and statistical purposes, you are exempted from all obtaining the consent and can be process personal data without obtaining the consent. But here also they talk about that you have to follow the standards mentioned in second schedule, so which talks about it can be only for a lawful purpose, and additional requirements of sending out the notice with the data principle that your data is being utilized for this purpose, and also for the purpose limitation wherein you can't use it for any other purpose apart from research, archiving, and statistical purposes. Then rule number 16 and onwards till rule number 21 talks about setting up the board and the operational process as to how the board and the committee would be set up. So basically it addresses that there would be chairman and then would be members, how they would be appointed, what would be their salary, what would be the procedure as to appoint their appointment, how would they have meetings. So one thing here to be noted is that for a meeting to take place, any proceeding before them has to be at least one third of the membership present, and it would be based on the voting criteria. And additional power has been given to the chairman in case there is an emergency that creeps in. Then the chairman can take any decisions wholly and solely and does not need to consult the members, and can after within 7 days circulate and have a meeting with the other board members. Also, interesting thing to note here is that they have told that this board would be a complete digital office. So we'll have the board also in a digital format. So we'll not have any physical office as such. It would be a digital office, as rule number 17 mentions. Then I talk about appeals. So the appeal has to be filed as we file in respect to the try appeals. And though there's no set timeline as to the period in which the appeal can be filed. Another interesting provision that is a point of contention when we talks about this rule and needs some clarity is the power given to the government, central government within rule number 22. So basically, deriving the power from section 35 of the act, it says that the central government would now have the power wherein it can call upon any authorized person or require any data fiduciary or intermediary for that function to furnish the information and specify the time period for in which that information has to be furnished, wherein they have to disclose the information that they are processing, and they can do so in the sovereignty and integrity of India for security of the state, that you furnish this information and then can stop you from disclosing any of this information to any other data processors or for that matter any data fiduciary without the prior permission of the central government. And apart from that, one thing here to note is they can call you, and based on the data that you submit to them, they can then assess whether you fall under the category of significant data fiduciary or not. So, Bhaskar, would you like to add anything to what?
I think I'm seeing the questions, and there's a lot of confusion about consent managers and data fiduciary. So let me just clarify. Consent manager is another category of entities which is there as an option. And I think the reason behind this, one of the reasons behind this is also the volume of data that is there in India, given the population of India. So this consent manager category, these companies will act as a point as a point of representation for the individuals who want to go through the consent managers, who want to provide the consent to a company, certain company, through a consent manager. And these consent managers will represent these individuals and manage their consents. Now, it's not mandatory. An individual can directly give the consent to the company or choose to go through a consent manager entity. So that's what this understanding is all about. It's not mandatory. It's not definite to have a consent manager for all the companies every time. I think that is what this act has also clarified when you talk about obligations of the data fiduciary under section 6 or 7. Yeah.
Right. Also, there is a question wherein it talks about whether these exemptions also apply to private entities when they are doing research, etc. So, if you read the rule, the provisions of the Act shall not apply to the processing of personal data necessary for research, archiving, or statistical purposes if it is carried on in accordance with the standards specified in Schedule 2. So when you see Schedule 2, it basically talks about states and instrumentality. Though the provision here itself does not mention that the private entities can't do it, but the schedule in the header itself, if I'll just show you the schedule also. So if you see to the, allow me 1 minute. This was so if you see the header here to the schedule, it says standard of processing of personal data by state and its instrumentality under section 7 and subsection 2 of section 17. So here a bit of reference can be drawn as to it is given to the state, but there is no clarity as such as in the individual's private individual would be covered or not. But as per a reading, it reflects that private individual may not be covered in this exception. I think we've covered the entire law, and I
Yeah.
think it's time as well. So we can wrap up this schedule, this session. And if you have any questions, or if you think your question has not been answered, you can contact us. You have our information, or if you require any other of our services or any of our explanation on anything, you can contact us. Over to you, Bhaskar.
Yeah, I think only one last question I am seeing that about the data bank of consent managers maintained to be maintained with the board. No, there's no provision of having data bank like which was there for independent directors, but no, there's no clarity on that for consent managers so far. That's all. And if you have any questions which remain unanswered, please reach out. Please directly message us, and we will respond to you. Thank you so much. Thank you for joining the session. Thank you, Mahima.
Thank you, everyone. Thank you for joining the session. Thank you for taking out your time and listening to our thing. Thank you. It was a pleasure hosting you all and reading this law together. Thank you.